year and over year with increasingly more stringent privacy requirements that would apply solely based on length of time, avoiding the problem of dealing with consent, which is clearly become recognized as a problem online activity.
Yeah, so let's talk about consent just for a second. One of the interesting speeches at the Madrid Conference of Data Protection Commissioners was a presentation by Professor Yves Poulet, a Brussels-based academic who has a great stature in the European regulator community. And I don't want to joke about his French, but it was sort of consent. And the audience, was that not French? Was that Yiddish? Is that Yiddish? Oi, French. In any case, in his elegant French way, he gave a very intellectual presentation deriding the notion of consent. And you saw a lot of people in the room, yeah. And obviously, as we've watched data protection interpretation and, different sorts of consent written into statutes, but yet being, well, no, it's not possible for the employee because he's under duress, so he, is forced to let you get his data so you can pay him, and other areas where consent has been minimized. Is consent in a incredibly complicated environment something people are going to manage to figure out? Is it just too complicated? Is the answer, like Bob said, just delete it and then you don't got to ask him as many questions if you're not going to have it too long? Are the Facebook, MySpace, are the privacy settings too tricky for anybody other than the sophisticated to understand? I've been stumbling off a lot of pictures that I'm seeing that I probably ought not to be seeing because they're, friends of friends. And do they know that I can see their pictures? And they're savvy people. They're all of us. And we're making those mistakes. So what do we do with the free market consent if it turns out it's kind of hard to do?
Well, both notice and consent have come along in a time when we're creating this almost entirely new world. And we, people in this room, really would like for the rest of the country and the rest of the world to intellectualize about privacy the same way we do. But very few products are designed because consumers think about it intellectually. It's a much more diverse, free-flowing process where market systems, the press, advocates, safety or education folks push and pull on the design of products until some consensus is reached. And so I wouldn't say that consent is ever really terribly useful, or it's useful for a tiny margin of users, but reputation and branding and things like that are more useful so that people can say, oh, this is a responsible operator. I'm gonna do business with them. I got on Amazon, I'm proud to say, because my dad said I should use it many years ago. And it'll be these kinds of processes, the marketplace push and pull, that converges on what makes sense to society as a whole. It won't be a billion individual decisions based on some notice and consent regime. And it's nice now that after a decade or so of struggling with notice, we're starting to realize that that notice isn't working, that it'll be this very complex but very large and ongoing discussion about the design of services that will determine how they work.
Let's throw open to questions from the floor after Parsley.
I just wanted to follow up on that. I think that's one of the areas where when you get industry together and they establish some best practices, really good things happen, especially if they're just allowed to work confidentially and look at what our consumers looking for, what can we do together. I keep saying participated with the Blue Ribbon Task Force that the cable industry put together. And it was very interesting to watch over the course of time industries that we knew did not do some certain things, that just through these conversations, they implemented new strategies and new investments in education that hadn't been there before the best practice discussions. So I don't think you can ever underestimate getting industries together and letting them look at some of these concepts together. Now, the part about the consent and the privacy settings, I think that's where we have to look at those early adopters. Who are the first people using this on both sides of the scale, the young and the older? And what can we do as industries to make that process of coming onto a new platform more understandable? So what can be done with the privacy settings? What can be done with actual tutorials that you can opt in to view? I think a great model is Flickr. When you go to Flickr and you look at their terms of service, it's really clear. It's very obvious, and anybody who can read English can really understand exactly what they expect. And that group spends they have a great record at keeping track and self-policing, so it comes back to this reputation piece. So I'm hoping that we don't get too far on the regulation side to recognize so much can be done by allowing industry to put their heads together and come up with best practices, and then they don't lose the option for innovation.
I don't know what Monsieur Poulet may have said, but often the failure of consent is an argument to establish what everybody should have, and that I think is very destructive to the innovation and experimentation process that we so benefit from.
Great. Yes, Braden.
Nat, first I'd like to say my mom is a public school teacher in Cobb County, and she distributed her pamphlets.
Great.
All good talking points to say to her class on that, and I think it went over very well.
What's the name of that pamphlet again? Can you hold it up for everybody?
NetCetera. Available at onguardonline.gov. And we may get in touch with your mom when we go back to the state.
I have a quick question. I wanted to pick up on the discussion that we're still having about consent and opt-in versus opt-out. Of course, you can't go at a privacy debate and not talk about opt-in and opt-out. But when it comes to reputation, I want to know more about how you think it actually fits in, because I understand how it might fit in from a company actually collecting data from you and what it might retain, and it might ask you like that. But in a social networking environment, which is kind of by virtue opt-in in a way, and then user-generated, which is also by virtue opt-in, is notice and consent, or is at least opt-in versus opt-out even a factor here?
I think absolutely it is a factor, and my teenage daughter, she has maximized what I end up being able to watch, because there's so many little granular settings you can set now that you didn't have the option 6 months ago or 12 months ago. And when I speak to youth, particularly when I was in Egypt recently, youth want more options for the images and the documents that they set out. And I think some of the very interesting research that came from the Microsoft study was that you can be judged or graded or rated by your friends' comments and what they're talking about and what they're posting, and learning how to hide people, learning how to manage the comments and things that are posted is really important, more now than ever, now that we can quantify.
Yes.
Hi, Tom Hickman with Common Sense Media. My question is, since we're talking about, we're in D.C., let's talk about regulation. With privacy, while reputation is a little amorphous, when you get down into personally identifiable information, you can get into some really troubling areas of identity theft. The MIT research that showed that you can triangulate health records. The question I have is, what do we need to do with the definition of personally identifiable information in regulation? It's clearly out of date, both in COPPA as well as in the Electronic Privacy Act. What do we need to do?
Well, I'm not going to say what we need to do. I mean, we're in the middle of a process to look at all of these issues, and so the third workshop, and currently planned to be the final one, will be March 17th back here in D.C. So I encourage people to be engaged in that if you haven't been engaged in one of the earlier ones. Those are the sort of issues. It's the same with opt-in and opt-out. I mean, these are big issues that touch on lots of different topics, from reputation to security to things like identity theft. And we're interested in hearing people's perspectives, learning about the research. I'm not part of the team that's doing that, but I'll be involved when we are then explaining back out to the world what it is that we've determined. And I was amazed to hear that Microsoft's trustworthy computing division is larger than the FTC's Bureau of Consumer Protection. But we do have lots of people, very sharp people, who are working hard on this, and I think we'll have thoughtful recommendations. But at this point, new definitions of PII, opt-in versus opt-out, are exactly the sort of things we're looking at, but it's premature for us to say where we think that's
a better retirement plan.
Personally identifiable is unfortunately not susceptible to a lasting definition, at least not while technology is changing. Other than a sort of common law style definition is if you can identify a person using this data, and that's there are many examples of identifiers that only weakly identify, but those identifiers in combination with others will more strongly identify. And so any statutory definition that isn't just does it identify is going to fall out of relevance. Data mining capabilities will advance and data collections will advance so that more information is personally identifiable. than has been in the past, and that's
Yeah, let me just throw out a couple of thoughts. First of all, we've always considered